Start. The power under Article 226 of the Constitution to issue writs can be exercised not only for the enforcement of fundamental rights but for any other purpose as well. The High Court has the discretion not to entertain a writ petition. One of the restrictions placed on the power of the High Court is where an effective alternate remedy is available to the aggrieved person. Exceptions to the rule of alternate remedy arise where a. The writ petition has been filed for the enforcement of a fundamental right protected by Part 3 of the Constitution. B. There has been a violation of the principles of natural justice. C. The order or proceedings are wholly without jurisdiction. Or D. The bias of a legislation is challenged. An alternate remedy by itself does not divest the High Court of its powers under Article 226 of the Constitution in an appropriate case, though ordinarily a writ petition should not be entertained when an efficacious alternate remedy is provided by law. When a right is created by a statute which itself prescribes the remedy or procedure for enforcing the right or liability, resort must be had to that particular statutory remedy before invoking the discretionary remedy under Article 226 of the Constitution. This rule of exhaustion of statutory remedies is a rule of policy, convenience, and discretion. In cases where there are disputed questions of fact, the High Court may decide to decline jurisdiction in a writ petition. However, if the High Court is objectively of the view that the nature of the controversy requires the exercise of its writ jurisdiction, such a view would not readily be interfered with. Learned counsel for the petitioner has not been able to demonstrate from the facts of this case as to how it would fall under any of the exceptional circumstances mentioned therein, or that the petitioner has been impeded from canvassing what is sought to be agitated in this writ petition in an application to set aside the arbitral award under section 34 of the ANC Act, and the affidavit filed in support of the writ petition is also bereft of any details in that regard. Coming to the requirement of making pre-deposit of 75% of the amount involved, it would be necessary to refer to section 19 of the MSMED Act, which reads as follows: application for setting aside decree, award, or order. No application for setting aside any decree, award, or other order made either by the council itself or by any institution or center providing alternate dispute resolution services to which a reference is made by the council shall be entertained by any court unless the appellant in bracket not being a supplier has deposited with it 75% of the amount in terms of the decree, award, or, as the case may be, the other order in the manner directed by such court, provided that pending disposal of the application to set aside the decree, award, or order, the court shall order that such percentage of the amount deposited shall be paid to the supplier as it considers reasonable under the circumstances of the case, subject to that conditions as it deems necessary to impose. The plain language of the aforesaid provision makes it clear that its compliance is mandatory, though the court has discretion to permit the buyer to remit the amount in installments as it may deem fit, as held by the Honorable Supreme Court of India in Gujarat State Disaster Management Authority versus Aska Equipments Limited in bracket 2022 1 SEC 61 in the following words on a plain / fair reading of Section 19 of the MSME Act 2006 reproduced herein above at the time / before entertaining the application for setting aside the award made under Section 34 of the Arbitration and Conciliation Act. The applicant has to deposit 75% of the amount in terms of the award as a pre-deposit. The requirement of deposit of 75% of the amount in terms of the award as a pre-deposit is mandatory. However, at the same time, considering the hardship which may be projected before the appellate court, and if the appellate court is satisfied that there shall be undue hardship caused to the applicant to deposit 75% of the awarded amount as a pre-deposit at a time, the court may allow the pre-deposit to be made in installments. The same view has been taken by the Honorable Supreme Court of India in the decisions in Goodyear India Limited versus Norton Intech Rubbers Private Limited in bracket 2012 6 SEC 345 and Tirupati Steels versus Sub Industrial Component in bracket 2022 7 SEC 429. The division bench of this court in Messrs. Eden Exports Company versus Union of India in bracket 2013 1 MLJ 445 has declined to entertain writ petitions challenging the orders passed by the Micro and Small Enterprises Facilitation Council when 75% of the amount involved as required under Section 19 of the MSMED Act has not been deposited before the matter is taken up for hearing. Moreover, in the absence